Understanding your authority as a licensed professional. One of the most powerful and often misunderstood rights you have as a licensed real estate professional in Arizona comes directly from the Arizona Constitution, Article 26. This law gives licensed brokers and salespersons the ability to prepare, draft, and complete documents related to real estate transactions without being considered the unauthorized practice of law. This includes documents such as purchase contracts, leases, assignments, and other instruments directly tied to real estate transactions. In property management, this right is used daily, often without agents even realizing how significant it is. For example, when you prepare a lease agreement for a rental property in Chandler or complete a renewal agreement for a tenant in Scottsdale, you are exercising a constitutional right granted specifically to licensed professionals. The key limitation: incident to the transaction. While Article 26 gives broad authority, it comes with an important limitation. The document must be incident to the transaction. This means you can only draft documents that are directly related to a real estate transaction in which you are acting as a broker or agent. For example, you can prepare a lease agreement for a property you manage, you can complete a property management agreement, you can draft amendments or addenda related to a lease. However, you cannot draft legal documents unrelated to a transaction. You cannot charge a separate fee specifically for drafting documents. You cannot act as an attorney or provide legal advice outside your scope. Think of it this way: you are filling in and facilitating documents, not practicing law. Real-world example where agents cross the line. A property manager in Phoenix decides to create a custom legal clause for all leases that significantly alters tenant rights. Even though the manager is licensed, this action may cross into the unauthorized practice of law if the clause is not standard or legally reviewed. The safer approach is to use approved forms, such as Arizona Association of Realtors (AER), AAR forms, or consult legal counsel when creating custom language. Key takeaway: just because you can draft documents does not mean you should create legal language from scratch. Tenant rights and essential services, when things go wrong. Let's connect this authority to real-life property management situations. Under ARS Paragraph 33-1364, if a landlord fails to provide essential services such as air conditioning, water, or electricity, the tenant has specific legal remedies. For example, imagine it is 120 degrees in Arizona, and the air conditioning in a rental property fails. The tenant notifies the property manager, but no action is taken. The tenant may obtain substitute housing and potentially recover costs. Be excused from paying rent during the period of non-compliance. Seek additional remedies if the failure was deliberate. This highlights an important connection. Your role is not just paperwork. It directly impacts people's living conditions and legal rights. Habitability, the non-negotiable standard. Under ARS, Paragraph 33-1324, landlords, and by extension, property managers, must maintain properties in a fit and habitable condition. This includes maintaining plumbing and electrical systems, heating and air conditioning, safe and clean common areas, waste removal systems. For example, if a property manager ignores a broken plumbing issue in Mesa, that is not just a maintenance oversight, it is a violation of Arizona law. Habitability is not optional. It is a legal requirement. Security deposits and accounting, best practice versus minimum requirement. Security deposit handling is another area where legal standards and best practices intersect. Under ARS Paragraph 33-1321, a tenant is entitled to an itemized accounting of deductions within 14 business days after move-out if they make a demand. However, best practice is to always provide that accounting, regardless of whether the tenant requests it. Let's look at a real scenario. A tenant is evicted and leaves no forwarding address. The landlord wants to apply the entire deposit toward unpaid rent. Technically, the statute requires a demand, but failing to provide an accounting can still create disputes or legal exposure. The best brokers do not just meet minimum standards, they exceed them. Final accounting. When a property management agreement ends. When a property management agreement is terminated, ARS Paragraph 32-2173 outlines very specific timelines for handling funds and records. Within 5 days, the broker must provide a list of tenant security obligations. Within 35 days, the broker must return remaining funds to the owner, except for amounts needed to cover outstanding obligations. Within 75 days, the broker must provide final accounting reports, including receivables, payables, and reconciliations. For example, if a property manager in Gilbert ends a management agreement but knows a vendor invoice is still pending, they may hold back the necessary funds, but must still comply with the timeline and documentation requirements. This is where organization and accounting systems become critical. Who can perform property management activities? Another important compliance issue involves who is allowed to perform certain tasks. Under ADRI guidance, non-licensees are limited in what they can do. For example, a maintenance worker cannot perform move-in or move-out inspections, as this is considered a licensed activity. This is a common mistake in property management. A broker may send a maintenance technician to complete a walkthrough inspection to save time, but this can create a violation. Delegation does not remove responsibility, especially when it involves licensed activities. How this section connects forward. This section ties together your legal authority, your limitations, and your responsibilities as a licensed professional. You now understand what you are allowed to do under Article 26, where the boundaries exist and how those boundaries connect directly to tenant rights, habitability, and financial accountability. As we move forward, we will build on this by diving deeper into trust accounts, accounting systems, and financial compliance, where these responsibilities become even more structured and regulated. Online discussion. What does incident to the transaction mean, and why is it important? Answer. It means that licensees can only draft documents directly related to a real estate transaction they are involved in, ensuring they do not engage in unauthorized legal practice. Why is habitability considered one of the most important responsibilities in property management? Answer. Because it directly impacts tenant safety and legal compliance, and failure to maintain habitability can result in legal action and financial penalties. What is the difference between meeting the law and following best practices in property management? Answer. Meeting the law satisfies minimum requirements, while best practices go beyond compliance to reduce risk, improve relationships, and prevent disputes.